Creation of a special needs trust. We know we need to use one, right? Everybody with me on that? Everybody feels like, yes, a special needs trust is something we need to consider. How should it be created? There are two ways. One is through a will, and the other is through what's called an inter vivos trust, or a trust that's in existence when it's created. A testamentary trust is simply a trust that will be created when your will is probated. And we're going to talk about some of the downsides to that. A will is simply a written document that's signed in a manner prescribed by law. Wills are very formal creatures, which disposes of property upon death. In Georgia, if you don't follow the formal procedures, you do not have a will. Some states, you can just handwrite your own will, sign and date it, and it's a will. Not so in Georgia. And usually it's along the East Coast, the more formal requirements you have. The further west you go, the less formal the requirements are. Anyone care to venture a guess as to why that's the case? As the country was developing, guess where all the lawyers were? They were along the East Coast. Very rarely do you see a movie about a lawyer moving west. Usually they're taking the train. So people are already there. It's already civilized. You know, you rarely see a lawyer on horseback riding out into the plains to set up shop. Lawyers need people. Without people, they have no customers. So along the East Coast, you see the more formal requirements. Further west you go, they had to be less formal because there weren't lawyers out there. So you had to be able to handwrite your own will. And that law just is simply carried over to modern day. A will nominates people who are responsible for wrapping up your affairs. We commonly refer to this as an executor or an executrix. The law is trying to get away from those old words and use the word personal representative, but most people still understand the word executor. In the will, you also nominate guardians for your children. And with a change to Georgia law about 2 years ago, you can now nominate guardians for your adult children as well. Used to, you couldn't do that. Now you can. And that's important, especially when you have special needs. Heirs, you might have a child who, when they're 20, 30, 40, will need to have a guardian name for them. You want to have a say-so in who that guardian might be. The court still has to be the one that does it, but this puts whoever you name at the top of the list who the court's going to consider. So it is helpful. In your will, you determine how and when your heirs are going to receive property you leave them. And you can do some tax planning in your will as well.